Hello, everyone, and welcome to One Civil Law. And for today, I have something different and something I thought I'd never see. We have a federal court of appeals judge who's dissenting in a Second Amendment case. That part isn't unique. The unique part is that he did it by video. He made a video dissenting on a Second Amendment issue, saying that gun rights are good and we should have some gun rights. And my fellow colleagues on the Ninth Circuit have their head up their ass. A federal judge did this. A federal court of appeals judge did this. Nonetheless, who told federal judges that video technology existed? Wow, this is amazing, and this is even more amazing because it's posted to the official United States Court of Appeals for the Ninth Circuit YouTube page. In the title of the video is Dissent Video in 23-55805 Duncan versus Bonita. Wow. A dissent video. Also, you have to love this guy right away because he has a replica AK-47 on his back wall in his chambers in his federal court building. Wow, this guy's based. All right, guy, what do you have on us on the law? Let's go.
Hi, I'm Judge Van Dyke, and welcome.
Hold on, gotta change the audio source, damn it.
Hi, I'm Judge Van Dyke, and welcome to my chambers.
Hi, Van Dyke.
I'm making this video as part of my opinion in the Duncan v. Bonta case.
Okay.
In this case, the state of California made the argument, which the majority has now accepted, that a magazine holding more than 10 rounds is just an accessory, not an arm protected by the Second Amendment's right of the people to keep and bear arms. I think anyone with a basic familiarity with firearms could show you that this attempted distinction is simply inconsistent with reality.
Yeah, that's going to be a bit of a tough sell. That a detachable magazine that holds more than 10 rounds is an accessory, because why would a detachable magazine that is less than 10 rounds not also be an accessory? What's the logic of that? And the answer is there is none. Now, you could differentiate it on a different basis. You could differentiate somehow saying that a magazine that holds less than 10 rounds is somehow within the scope of the right to keep and bear arms, versus saying a magazine that holds more than 10 rounds is somehow not within the scope. You could try to differentiate it that way. Incidentally, whether the case law would support that differentiation is a whole nother set of problems. But at least in theory, there might be some cutoff where it's within the scope or not. But to say that the magazine as such is an accessory, not part of the arm, is one hell of an issue, because of course, the vast majority of firearms use detachable magazines. And so, well, if the magazine is an accessory, then we can prevent you from having any magazine in principle, because it's not part of the right to keep and bear arms. So now you have a gun that has a detachable magazine, but no detachable magazine. So how much value does that have? I guess you can have one in the chamber. So one and done, I guess. All right. So that, yeah, trying to differentiate on that basis is gonna be a problem. All right, what else you got?
To this during oral argument when I asked California's counsel about the balance of the test that it proposed for what qualifies as an arm protected by the Second Amendment. Let's go to that exchange now.
Magazine and
Can I ask you a question about that? Because
yes, Your Honor.
So the way you're treating magazines, it seems like you could use the same sort of rationale as between a non-semi-automatic firearm, say a lever action or a bolt action or a revolver type action, and a semi-automatic firearm. So I'm trying to figure out, if you're saying, well, what we do is we say, have people ever banned particularly dangerous rounds? And now we're saying large capacity magazines are particularly dangerous. Why couldn't that same reasoning be used to ban semi-automatic firearms altogether? To say, because I mean, think about it, like during the Revolutionary War, if the United States had semi-automatic firearms that only held 5 to 10 rounds, it'd have been about 10 minutes and it would have been over, right, as against muskets. So clearly, the semi-automatic mechanism is way, 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 way more particularly dangerous than the difference, the delta between a 10-round magazine and a 15-round magazine.
Fair point.
So why does your reasoning not mean that, if this reasoning works, why does your reasoning not mean that a state could just ban the semi-automatic firearms altogether?
So if
Yeah, that's a pretty good point, the delta between a firearm that has, say, an 8-round magazine and a 15-round magazine, the delta of dangerousness between those two is not as great as the delta between the firearm that has an 8-round magazine and muskets. So if it's based on the particular dangerousness, if that's the rationale, then why can't we just ban all semi-automatic firearms? That's a pretty good question. What you got, California?
If we're just start talking, Your Honor, about this initial sort of textual question, I think if you're dealing with a semi-automatic, that would fit the definition of an arm.
No, but that semi-automatic could be a revolver. Like it could be, I mean, just like this, that high capacity magazine could be a lower capacity magazine.
Right.
Right, Your Honor. So I think that would fit the definition of arm, and then you'd move on to the other aspects of the Bruin analysis. At stage 1, is a particular weapon that's being addressed by the law in the tradition of dangerous and unusual? Is it in common use for self-defense? And we think Heller is clear that has to consider the character as well.
I'm not understanding I think I'm missing your response to my. It seems to me that just as you could say, are you saying that yes, so it would be an arm under, you're not conceding that it would be an arm under stage 1. So why are you saying it wouldn't be an arm, but the semi-automatic versus revolver, say, distinction is something that we're stuck with? I mean, you would agree that you can't ban the automatic mechanism.
Well, an automatic mechanism, I think that you can ban. I think the Supreme Court has recognized
No, the automatic mechanism is a term that semi-autos and full autos use an automatic mechanism.
Sure, Your Honor. I'm sorry for the confusion. No, I don't think that we could ban all semi-automatic weapons. I think Heller makes that clear. The point I was just making is, with respect to accessories, I think we have a difference of opinion where my friends suggest any accessory that is somehow helpful to armed self-defense.
That's important, because your argument turns on whether you can characterize accessory. So you would say that the revolver versus semi-automatic is not an accessory, but that a magazine is this accessory. So what would you think about like a red dot sight, electro-optics, which many firearms are going to electronic optics nowadays. They're obviously an accessory because you could have iron sights. Could you ban those?
Well, so, Your Honor, I'm not intimately familiar with that, and I do want to answer this question and make sure that I save time for rebuttal. I think that the question at the outset would be, is that, if it's an accessory, is it within the Teixeira principle that it's necessary to the realization of the right to self-defense? And you'd have to build...
Well, if that's your definition of accessory within the scope of the Second Amendment, then a detachable magazine is necessary to the functioning of a detachable magazine firearm, which, again, vast majority of firearms are detachable magazine. So magazines, generally speaking, would be within the scope of the Second Amendment right, because they are essential, if that's how you're defining it. So you can't, so you're trying to argue, I'm trying to understand California's argument within its own frame, and I'm having trouble. So it's like you're trying to argue that a 10-round magazine is essential to being able to function the firearm, but say a 15-round magazine isn't essential. It's like, okay, but if that's true, then why is a 10-round magazine essential as opposed to a 5-round magazine? Why is a 5-round magazine essential as opposed to a 3-round magazine? Depending on the type of firearm we're talking about, some magazines only are 5 rounds. So that, so why is that essential? Wouldn't a 3-round magazine work just as well? For example, shotguns. A standard 870 pump shotgun, for example, I believe has an 8-round tube. If you're going to use it for hunting, however, if you're going to use it for bird hunting, you're required by law to have that only hold 2 rounds in the tube. And they have a little plastic thing that you can put in there to restrict the magazine size. That's part of the Migratory Bird Treaty Act with Canada from 18 whatever. So it's like, okay, so a 2-round tube is considered sufficient for bird hunting. So it's not therefore essential to have the 8-round tube. So can we therefore restrict all shotguns to be 2-round tubes? I mean, if it works for bird hunting, why not for other purposes, right? So how does this work? How do you draw the line between essential and non-essential in a way that says, okay, 10 rounds is constitutionally essential. That's the constitutional cutoff point. It's like, how are you getting to that? And the answer is, as far as I can tell, you're not getting to that. The logic would allow you to say, well, no, when we said 10, what we meant was 8. When we said 8, what we meant was 6. Right? There's no rational cutoff point, and that's the judge's point. Within the meaning of it being an accessory, there's no rational cutoff point. So California's answer sucks.
The record and analyze it in that case.
So, counsel, you're saying?
Now, from this exchange, it became clear to me that many, including both California's counsel and my colleagues in the majority in this case, lack the basic familiarity with firearms to understand the inherent shortcomings and obvious inadmissibility of the test that California was proposing, and which the majority in this case has now adopted. I originally planned to explain all of this in writing, in my opinion, and why the argument doesn't make sense, but it occurred to me that in this instance, showing is much more effective than telling.
Are you about to do a show and tell with firearms in a federal court building in California? Based.
As the old saying goes, a picture is sometimes worth 1,000 words. And here I hope you will agree that a video is at least worth that much. And I suppose at this point in the video is as good a time as any to apologize for any shortcomings of the video. This is the first video like this that I've ever made. And in our digital age,
I think it's the first video any judge has ever made like this ever. This is different.
I fear that people have become accustomed to a production quality that I'm sure that I fall far short of.
Nate, the lawyer for 999, says California argues magazines are accessories so they can be regulated. You have a right to one bullet mag, not more. Yeah, Nate, the lawyer, that does seem to be the logic of their position. So I've already noted this problem. You're very right. $5 from Pin King 554. Ninth Circuit has almost always been anti-gun. Did I notice the AK in the background? I did notice it. I mentioned it at the start of the stream. It's pretty based.
But I hope and expect that regardless of any such flaws, this video will still powerfully serve the purpose for which I've made it. I also want to emphasize that for safety purposes, I have rendered inoperable all the guns and gun parts that I used to demonstrate today. And finally, as an appellate body, it's obviously not our role to make factual determinations, so I share this not to supplement the factual record that we're using to decide this case. Instead, I share this because a rudimentary understanding of how guns are made, sold, used, and commonly modified makes obvious why California's proposed test and the one my colleagues are adopting today simply does not work. I'm sure I could explain all of this in writing without being accused of improper fact-finding, but it's obviously much more effective to simply show you. So let's do that now. Welcome back. To demonstrate...
Holy shit. He's got guns. He's got them on display in a federal court building. Based.
I'm going to start with this SIG P320 that's basically in its stock configuration. That is, this gun is basically in the same configuration it would come to you from the manufacturer and be sold to you at a retailer. This is one of the most popular handguns currently on the market in the United States.
Is he breaking the law right now by bringing a handgun into a federal building? Maybe the FBI wants to look into that.
So I'm going to use this to point out some of the essential parts of a handgun. These same parts would exist on pretty much every handgun, at least of this semi-automatic type. So let me start by pointing out a few of them. This one comes with a standard 21-round magazine. Comes from factory just like that. You can buy a similar version that comes with a 17-round magazine that fits flush. And so it comes with a 21 or 17-round magazine. It has a standard full-size grip. It has a factory trigger, which has a pull weight of about 7 pounds or so. Has front and rear iron sights that are used to aim the firearm. It has this little takedown lever, which is small, and you may have trouble seeing it, but we're going to talk about that some later. And that's what you use to remove the slide and disassemble the firearm. And the entire gun is designed around the automatic cycling mechanism. That is, when you pull the trigger and fire a round, right when that happens, it automatically will rack the slide back, eject the round, the spent cartridge out of the gun. It will grab a new round out of the magazine, put that round into the chamber, into the barrel, and it'll be ready to fire another round the next time you pull the trigger. So this is a semi-automatic firearm. Now, I want to use this handgun to illustrate.
The man's got zoom in, zoom out effects. The man's got editing in his video. This also is surprisingly well shot with very good audio, incidentally. For his first video, he's doing pretty good.
First, California and the majority's argument as applied to this obviously typical and very common.
Also, nice deer painting behind you. Respect.
Handgun, and then I want to show.
And who is this bobblehead on his shelf? I can't quite tell who that's a bobblehead of. But he's got actually more than, he's got a big bobblehead on, he's actually got multiple bobbleheads. He's got, okay, so in the bottom shelf, he's got a bobblehead, I can't quite tell. And then above that, he's got two little bobbleheads. And then above that, he's got what looks like some Supreme Court bobbleheads. I think that's Justice Thomas back there. And then above that, I don't know who that is. He likes the bobbleheads though. Okay, noted.
That the same argument would apply to other parts of the firearm and to this firearm as a whole. Now, as a reminder, California's argument, which the majority's adopted here, is that a magazine that holds more than 10 rounds is not an arm protected by the Second Amendment. So this 21-round magazine that comes from the factory or a 17-round magazine is not an arm protected by the Second Amendment. Now, California acknowledges that a magazine is necessary to make the firearm function, but
yes,
they argue that because you can replace the standard magazine with one that holds fewer rounds, 10 rounds or less, then these higher capacity magazines are not an arm and thus wholly unprotected by the Second Amendment.
Which then by logic, any magazine of any size would be equally good. So a 1-round magazine would also be legally sufficient by logic, which I'm sure is where California would want to go in there if they had their druthers.
Now, the problem with California's argument is that, as I pointed out in oral argument, the exact same argument would apply to essentially every part on this firearm, which would mean that essentially nothing on this firearm would be protected by the Second Amendment. Allow me to illustrate that using this firearm. Now, in oral argument, I asked California's counsel.
I mean, I do appreciate him going to other accessories to highlight how it's a broader point, but I think to some degree it's a slight mistake. But I think the better argument is just by focusing on the magazine itself. It's like, yes, by your logic, this would also prevent red dot sights, but I feel like that's slightly off point, with all due respect, Your Honor. Better is, by your logic, this would allow California to have 1-round magazines, would be a better argument that would be closer to the point. But fair enough.
The argument meant that the sights on this firearm are not protected by the Second Amendment. And part of the reason I'm making this video is because it didn't appear that counsel understood what I was asking. So
no, probably not.
This handgun. What you see on here are iron sights. You have a front and a rear iron sight. And the way that you fire this handgun, the way you aim it, is you take and you line up these two sights and you line them up on what you want to shoot at. And that's how you... Also, Springfield here getting, or is this SIG? I forget. Well, either way, this gun manufacturer is getting some official... Does this qualify as a as an ad? They're getting their ad for their gun about how awesome they are from a federal judge in his chambers. Based. You hit what you're aiming at with this firearm. These are iron sights. They're probably the most common sighting system for a handgun. But all you have to do on this particular handgun to change out the sights is remove 2 screws in this slide right here, and the back sight comes off. And when you do that, you can put the 2 screws.
Did he get that firearm for free? Is this a sponsored video? I have questions.
Back into a red dot optic, and now you will have a firearm that, instead of having iron sights, would have a red dot optic. Let me illustrate that by just taking a slide where I've already installed the red dot optic, and here you go. See, so now you have this back iron sight's been taken off, and here's a red dot optic. Now, in the hands of an experienced shooter, this red dot optic allows you to shoot the firearm more quickly, to get on target more quickly, to hit what you're aiming at, be more accurate. And so it's obviously much more dangerous if it's being used for an unlawful or wrong purpose. But if it's being used for a lawful purpose, then it makes the firearm better for that intended purpose. So this firearm would be better for self-defense or competition, recreational shooting, or hunting. And indeed, my own self-defense handgun, which this is another P320 that's been configured.
Holy shit. Is this his personal carry? Is this his personal daily carry that we're doing right now? Holy shit.
Figure slightly differently, has a red dot optic precisely because it makes the firearm better for its intended purpose, that is self-defense. It makes it more accurate more quickly and shoot more quickly. Now, so in that sense, this red dot optic is just like this magazine. It makes the firearm more dangerous when it's misused, but it also makes the firearm work better for its intended purpose when it's used properly. Well, you may think that's pretty intuitive about the sighting system for a firearm, but the same thing is true about basically every part of this gun. Let's take a look at a part that's maybe a little less intuitive, which is that takedown lever that I talked about earlier. This little piece here is necessary for the operation of the firearm. It's a tiny little piece that you need to have for the firearm. And so you would think, well, since it's necessary, then it must be an arm protected by the Second Amendment. But not under California's logic in this case. See,
Fair.
You can replace this factory takedown lever with a different factory takedown lever.
Yeah, and I've actually done that. You know, for my Glock, I replaced the takedown lever 16 with the Glock 19. I replaced it with the Glock 34 lever. It's a longer lever. So I did do that. So you can in fact do that. So yeah. So this guy knows how to change parts. This guy knows how to actually field strip a firearm. He knows how to change components. Maybe he can show us basic maintenance. Maybe he can show us basic cleaning, and he could have a video how to do basic field stripping and cleaning of your 6 hour.
It's called a gas pedal. And when you do that, you replace it, you put the slide back on. Now the firearm is a lot more controllable under recoil. You can, just like with the red dot sight, you can do faster follow-up shots. You can aim the gun more quickly, and you can control it better. So again, as with the red dot sight, as with the higher capacity magazine, this particular takedown lever makes the gun more dangerous when it's misused, but also makes the gun more effective for its intended purpose when it's used properly. So under California's logic, because this is an accessory, this little takedown lever, and could be replaced with a worse part, this little takedown lever is not protected. It's not part of the arm protected by.
Also, and here's a question I actually don't know the answer to. Does this video count as part of the official dissent? He wrote a dissent, but this video is published on the Court of Appeals for Ninth Circuit website. Is this video now part of the official dissent? Are we doing dissents in video form now? That's an interesting revelation if that's what's happening, because I think it might be what's happening. Is this the first video legal is this the first judge's legal opinion done in a video? To be distinguished from merely, filming, the court scene, which is not quite the same thing. This is a formal legal opinion. Is this the first formal legal opinion done on a video? How do you cite this? Does the blue book need to be updated? How do you cite this?
The Second Amendment. Well, you might ask yourself, well, what about the grip? Like, you think this grip, certainly it must be part of the arm. I mean, it seems like that's a pretty key part of a firearm, is the grip of a pistol. Well, actually, under the majority's argument, it would not be protected. And the reason is,
I could do a law review on this. I might actually do it, which would be hilarious. And also, incidentally, does this qualify as a law review on this, which might now do? We're into some very weird territory at this point. I was like, I could do a formal legal review on this. And then wait a second. It's like, wait a second. Aren't I already doing a formal legal review on this? Is this a law review? This channel used to be called Internet Law Review. Is this a law review now? These borders are getting fuzzy. Questions are being asked. What else do you got in the bag? What's in the bag?
Here's a bunch of grips.
Holy shit. There's more guns and more grips in the bag. Okay, great. This guy pulls out, you know, a minigun or something, I'm going to lose it.
I accumulated over the years. I'm just going to pull a couple out here. This is a nice small grip, a nice small light grip. This is a big heavy grip. So what you can do on this firearm is you can remove the slide, remove that takedown lever, take what's called the fire control unit out of the firearm. This is actually the firearm under the ATF's definition. And you can take this fire control lever and you can put it inside this smaller grip. And you could use this grip for...
The man is now making and assembling guns. He's making and assembling guns in the federal courthouse. Awesome.
Say self-defense purposes, because it's very concealable, it's light, it's easy to carry, and indeed you'll see that's pretty much the type of grip that I have on my self-defense firearm. Or you could take this much heavier grip with aggressive stippling on it and with a flared mag well, and you could put this fire control unit in there. Put the
I wonder if I could contact this judge and wonder if we could go shooting together. That'd be fun. It's like, will you appear on my channel? And if so, will you go shooting with me first? He'll probably kick my ass, but it'll be fun. I haven't been shooting in a while. My skills are lame. So he'll probably kick my ass, but it'll be the most interesting judicial interview ever.
Put the takedown lever on, and then you put the slide back on, and now you have a firearm that is much better at being able to take quick follow-up shots, hit what you're aiming at. And so this grip, all of these grips under the majority in California's logic could be banned because if they were misused, they would make the firearm more dangerous, and you could put a different type of grip on if you wanted to. So you might ask yourself, well, what part of this pistol would be protected as an arm under the majority's logic? Well, I suppose California would eventually be forced to say, well, this part, the FCU, I guess, is the arm protected by the Second Amendment. Every other part that you added, as I've just shown you, every other part that you added could easily be characterized, just like the magazine, as an accessory that you add to the firearm.
I mean, that's a fair point. I think he's slightly off still by just not focusing on the logic of the magazine itself, but he's right. Because what exactly is the firearm? And the typical answer to that is, you know, basically the lower. And in this context, it is this fire control unit is the thing, because it is separable from the polymer grip. So basically, this is the legal firearm per ATF purposes. So basically, everything else is an accessory. And so you could ban everything except perhaps one potential configuration. And also, incidentally, by logic, because this firearm can be built this way, every firearm could be built this way. So if California wanted to, they could require every handgun to basically be built only one way. It would have to have a certain grip, a certain trigger, a certain barrel, a certain manufacturing material, certain sights. I mean, they could basically control everything, because as long as they gave you one configuration, they could argue that any other configuration is not strictly speaking necessary. The gun will work in one configuration, so we can limit you to that one configuration. Anything else is bonus by our large S. And then, of course, California probably would pick the configuration that, you know, makes the gun the least usable, the most undesirable. They'd pick the thing that would make the gun as ugly and unattractive in multiple dimensions as possible. They make it as challenging as possible, unergonomic, you know, they maybe like with a really, really long barrel, all handguns have to have a 25-inch barrel. I don't know what they do, but they try to make it as impractical as can be like, well, it will work, so everything else is optional. So the judge isn't wrong on the logic. That's facts.
And therefore could be banned under the Second Amendment. But not so fast. Even this part, the FCU, the core basic part of the firearm, could be banned under the majority's rationale. And the reason is, let me show you another FCU. This is the FCU for my competition gun. It has a really nice trigger, a nice light, crisp trigger, and has some parts replaced in here. It makes for a really nice trigger. You can upgrade the trigger to make it much nicer. And so because of that, under the majority's logic, you could even ban this FCU, or at least most of it, as simply an accessory under the...
Yeah, I mean, again, correct. You would have to get down to like, what is the actual firearm, and everything after that is bonus. And we could limit you to one configuration. So you're not allowed your competition trigger because the gun can be made without a competition trigger. And so therefore it is not necessary. A non-competition trigger will work. So again, we're going to give you a 25-inch barrel, and we're going to give you a 20-pound trigger, and we're going to do a 1-round mag, and we're going to make the gun, it will work, it will function. But yeah, we're going to make it as difficult as possible. Thank you, Mandy, for the gift membership. Always appreciated.
And now protected by the Second Amendment. Now, most of what I've shown you could, I suppose, be conceptualized as upgrades. You say, well, that's an upgraded trigger, and that's an upgraded takedown lever, and that's an upgraded grip. But the majority's logic works both ways. I've just shown you how you could easily improve the sights, how you could easily improve the takedown lever, you can improve the grip and the trigger, you could do the same thing with the barrel. But you could easily downgrade all of these factors
exactly.
of the handgun to make the firearm less accurate.
Exactly.
You could put in worse than factory trigger. You could require worse sights than what it comes with from the factory.
Yep.
You could require a grip be put on that hurts the speed and accuracy. Indeed, this type of downgrade is precisely what the majority is actually requiring in this case, as we mentioned.
Yep, exactly. Yeah, the judge and I are basically right. If this logic works, the California can make the gun as unattractive, unusable, and as useless as possible. They can go to wherever the minimum threshold is. And under California's logic, the minimum threshold is pretty minimal. So, yep, that sounds about right.
Mentioned earlier, this comes from the factory with a 21-round magazine, or it comes with a 17-round magazine in a slightly different configuration, but the majority is requiring that these factory standard parts be replaced with worse than factory parts.
Yes, correct.
A 10-round magazine.
Yep.
So when we take everything off that the majority might call it accessory, what we're left with at best is this fire control unit, and as I've explained, even that could be dumbed down so that much of this fire control unit would be an accessory under California's argument. And of course, you can't shoot this, right? It's inoperable. You need all the other accessories that I've been describing in order to make this work as a firearm. But of course, also, each of these other pieces, just like this magazine, could in some way be considered an accessory, since they could be replaced with a different
facts
that would be less useful and make the gun less dangerous if misused. And that could be said for pretty much every single part of this handgun. And the same problem with the majority's...
Maybe this guy needs to take up gunsmithing as a hobby. After all, I'm trying to take up watchmaking as a hobby. If this guy takes up gunsmithing as a hobby, I will buy one of your firearms, sir. Put me down. I will buy one of your Ninth Circuit made. If it's made inside the courthouse, if you could somehow find a way to manufacture it inside the Ninth Circuit courthouse in particular, I am here for it. Put me down for one of your custom-made firearms. I'm willing to go through an FFL. I'm willing to go through a background check. I'm willing to do all those things, no problem. Put me down for one of your firearms, sir. I'm in. Let's go.
Argument applies to other aspects of the firearm that are less easily shown in the video, including fundamental aspects of how this firearm operates. At oral argument, I asked California's counsel why California couldn't ban the automatic cycling mechanism altogether under the California's argument. And again, I don't think he understood what I was talking about. Well, this handgun uses that mechanism. This uses the automatic cycling mechanism. And this semi-automatic auto-loading operation is the most popular mechanism that exists today and is used for self-defense. But other mechanisms exist for handguns, including probably most obviously the revolver mechanism. Here's a revolver. Think of the 6-shooter from the old Western movies, right? You can have a revolver which is not automatic, or you could have, and there's different types of revolvers. There's single shots, there's double actions. You could have the lever action, you could have a pump action, you could have a single shot break action, which only has one round. You have to open it up and manually take the round out and put another in.
Right.
And under California's argument, because any of these single types of mechanisms are not essential to make this handgun work, and thus, or make a handgun work, and thus are not an arm under the Second Amendment, California could ban the whole semi-automatic mechanism altogether, thereby effectively banning semi-automatic.
I don't know if they can quite do that under their own logic. I think you might have jumped the shark on the logic of the thing, because California knows that they're stuck with Heller, McDonald, and Bruin, and they can't get rid of all semi-automatic firearms as much as they'd like to try. So I don't think they can necessarily go that far and say, oh, that the semi-automatic control mechanism itself is an accessory because we could have a revolver. It's like, yeah, I don't think they can quite go that far. Not to say California wouldn't want to go that far, but I don't think they can do that under their own logic. But I appreciate the hyperbole anyway.
Handguns altogether, forcing everyone to use revolvers or single-shot handguns or worse. And of course, with bad sights, crazy heavy trigger pulls.
Yeah, California hasn't outlawed ammo and required non-lethal rounds, neo-dark matter. Well, as to that, I don't know whether or not they necessarily have or not. I know some states have banned particular kinds of ammo, but your point is well made. Your point is well made. California could, by this logic, presumably restrict ammo because it would work. And they could restrict the ammo to whatever would be the most inconvenient form of the ammo. And they could maybe they choose a configuration of ammo that's very, very expensive to make. I'm not sure what that would be, but perhaps there's a way to do that technically. Perhaps there's some sort of like technical requirement you could make that would be very difficult to manufacture, and so it would drive up the cost of the ammo. Maybe you could do that under California's logic. $10 from Christopher Driscoll. By California's logic, your political speech can be limited to set accepted phrases. Only so many configurations of words are necessary and acceptable. Limit dangerous ideas and innovation. Not an invalid point. Christopher Driscoll, not an invalid point. Because under this logic, California might be able to say there's only one valid way to express an idea. You can express any idea you want. If they can't limit you that way. But they might be able to say, well, the idea can be expressed using exactly these words. And these words are functional. They'll work. They may not necessarily be as good as your words. You know, your words are the equivalent of the competition trigger. Your words are the equivalent of the red dot sight. You know, they're nice, but they're not strictly speaking necessary. So under this logic, could you limit you to set phrases in political speech? Not an invalid comparison. I also enjoy First Amendment, Second Amendment comparisons because I think it's a very good way of reasoning in general. Obviously, like all analogies break down at some point, so you can't take everything to the wall, but it's a very good place to start because I find, at least in my own mind, the language between the First Amendment and Second Amendment to be extremely similar. And I find that the sort of overarching 50,000-foot overview principles that apply to the First Amendment also apply to the Second Amendment. So reasoning by First Amendment analogy always makes a warm place in my heart. So I appreciate your super chat. Thank you.
A terrible grip. You get the point. Ultimately, California's argument, which the majority has unwisely adopted here, is based on the unstated assumption that there's some basic, I guess, unadorned, without any accessories firearm that would be protected as an arm under the text of the Second Amendment.
The Venetian man of firearms. The prototype man of firearms. Exactly this firearm and nothing else. Truth.
But everything else is merely an unprotected accessory that's been added to that firearm that's unprotected. And I hope you can tell from this video that that idea is simply unrealistic and could never be applied in real life. Like many of this court's ideas about the Second Amendment, It stems from a big
Yeah, the Ninth Circuit is not exactly known for their brilliance on the on Second Amendment issues. The Ninth Circuit has been a bit hostile to firearms issues, as one would note. And this is part of the reason I feel that the Supreme Court really just needs to take up more Second Amendment cases in general. The thing about the First Amendment is I can tell you a lot about the First Amendment because there's a lot of First Amendment cases. So if you ask me the question about, well, what exactly is the freedom of speech? What exactly is that? Is the freedom of speech the same as speech? I'd say no. The freedom of speech is not speech. It's not the same thing. It's a different concept. They're similar, but not the same. And so if you ask me, okay, what is the freedom of speech? I'd be like, aha, I can answer that question. And the reason I can answer that question is because I've got uber case law telling me on this in multiple different ways, in so many cases on First Amendment law, spelling out exactly what the First Amendment is in some excruciating levels of detail. And so if you ask me, what are arms within the meaning of the Second Amendment? I'm basically like, I don't know. And the reason I don't know is because there's not really any cases. The Supreme Court takes up a couple First Amendment cases every single year. And they've been doing that since they discovered the First Amendment existed sometime in the late 1930s. So they've been doing it for basically 80 or 90 years to varying degrees. So there's a couple hundred First Amendment cases that speak to this issue. And on the Second Amendment, not so much. We've got Heller, McDonald, Bruin, and if you want to count it, we've got, what's the case with the sawed-off shotgun one? Miller. We got Miller from way back in the day, although I think Miller's best ignored because I still don't understand what Miller says. It's just not well written. And there are some not well written First Amendment cases, but that's not that big a problem because I've got several hundred other cases. So, not every First Amendment case is necessarily a banger. Some of them are not necessarily as clear as others, but that's okay. I've got a couple hundred others. I don't have that in Second Amendment land. The Supreme Court just needs to take up more Second Amendment cases so we can start defining the boundaries a lot better and so we understand what we're talking about. They just need to take more Second Amendment cases. But for some reason, they're not doing it. They should be hearing 5 Second Amendment cases every single year. Not for the least of reasons that the Second Amendment needs more love by comparison. There's lots of First Amendment cases. There's lots of Fourth Amendment cases. There's Fifth and Sixth and Seventh and Eighth Amendment cases. It's like the Second Amendment just needs some love. They need to do 10 Second Amendment cases every year. It just needs some love. It needs to be developed, man. Get with it, Supreme Court.
basic misunderstanding of how firearms work, combined with a highly unrealistic idea of how such a rule would be administered in real life. Ultimately, the only rule that makes sense and comports with reality and the text of the Constitution is that the entire handgun here, including the grip, this takedown lever, the slide and barrel, the sighting system, and this magazine are all a part of the arm within the meaning of the Second Amendment. Thank you for watching.
I enjoyed your video very, very much, Your Honor. I enjoyed your video and I enjoyed your dissent. And I share your concerns and reason. California's position doesn't seem to have a reason, it doesn't seem to have a logical breaking point. And that's one of the questions you ask in law a lot. And you hear the Supreme Court ask that in hypotheticals in different ways. Basically, does your logic break? Or what are the limits of your position? Is a question. So where does your position stop? And sometimes the answer is it doesn't stop. Sometimes there is no answer, but that's one of the questions the Supreme Court and other courts worry about. Is like, okay, where does it stop? It's like, if this is true, what else is true? Right? That's just logical reasoning. If this is true, what else is true? And so it's like, this video boils down to the judge saying, okay, if it is true that magazines that are greater than 10 rounds are a accessory, if that is true, what else is true? And the judge's questions are basically, he can't find a reasoned point to separate it. And he asked California during oral argument, and California doesn't seem to even understand the question either. Possibly because they don't understand firearms, possibly because they don't think there are limits or shouldn't be limits. But his point is overall valid. It's like, what are the boundaries of your position? And can't this extend by its logic to magazines that are 8 rounds or 6 rounds or 3 rounds? Can it extend by its logic to red dot sights versus iron sights? Can it extend by its logic to barrels that are 10 inches long versus 2 inches long? Can it extend by its logic to the grip and how it's made and its ergonomics and so forth and so on? It's like, yes, by its logic, it can. And so basically then you'd be left with, as in the ultimate reductionist case, you'd be left with the one true firearm. And if you say, well, that's reducto ad absurdum, that's kind of the point. It's kind of supposed to be reducto ad absurdum because he's asking you where the boundaries are, right? By your logic, why can't we go all the way to this wall? What's stopping it? If you think this is a reduction to the absurd, okay, fine. What makes it absurd? Where is the point of absurdity? Can you help me out on this reasoning? And he can't find it. And he has the misfortune of being on the Ninth Circuit, where the Ninth Circuit gets a lot of gun cases wrong, and I assume is extremely frustrated by the stupid. Because the Ninth Circuit just likes to restrict all the things forever because they don't like firearms. And as I mentioned, the Supreme Court at the moment isn't really stopping them because the Ninth Circuit has not given sufficient guidance. The Ninth Circuit, this is really a Supreme Court fail, even more than a Ninth Circuit fail. The Supreme Court just needs to whack around the Ninth Circuit and all the other circuits on the firearms issues and start defining the boundaries so that they'll stop playing as many games. And now they're not going to stop for a while. They're going to still play games. They still play games on the First Amendment. That's why we have a couple First Amendment games every year. So it won't stop them from playing games, but it will stop the games that they can play. The games they have to play are less egregious because they don't have as much turf to work with. And we still have to whack them into place. But that's part of the Supreme Court's job, and they're just not doing it right now. So all those things. So let me just see if there were a couple things in chat that I can respond to. Danny Brown says the absurdity soon becomes reality. And as to the magazine size, we've already seen that. We've already seen jurisdictions say, oh, no, not 10 rounds, 8 rounds, not 5. We've already seen jurisdictions try to do this. So it's also not absurd because they have been trying to do it. So there's that too. Yeah, massively large slippery slope. Yeah, slippery slope is not really a formal logical fallacy. It's kind of a informal fallacy because slippery slope is just because of X, therefore necessarily Y. Because I did X, I must do Y. That's slippery slope. It's strictly speaking not slippery slope if I say because of X, you can do Y. That's not slippery slope. Slippery slope is only it must occur, not that it can't occur. So you have to remember what slippery slope is, and no one ever does. Right? Just because California passed a law saying 10-round magazines doesn't mean they have to pass around a law on 8-round magazines. Doesn't mean they have to. But can they? Yeah, that's not slippery slope. That's something different. Yes, the judge is definitely based. Or more to the point, he's logical and reasoned. And I assume without knowing for sure that this judge also thinks that there's boundaries and borders of the Second Amendment. So I don't know what he thinks those are. I don't know necessarily whether he would agree with my overarching view of the Second Amendment. That might be interesting. But I assume that he thinks that there's boundaries and borders. But the problem is California is kind of trying to run the other way and say there are no boundaries and borders. And he's like, no, there are boundaries and borders. But you're trying to basically get this down to the lowest common denominator, and that's just dumb. Yeah, Neo Dark Matter says state issued firearms, maybe state manufactured firearms. Yeah, state manufactures firearms made under a license. Yeah, only this firearm. Other companies can make it, but only this one. Yeah. All right, that looks like all the comments that I see in the YouTube comments right now. So I will simply say I appreciate your time and thank you for joining me. This has been a fun video, and if judges do this more, I'm here for it. I want more legal opinions in video form. Maybe we can do a little skit. Maybe we could do a musical. That could be fun. Maybe we could stage it. And we could have like people playing parts, you know, in a dramatic performance, maybe an opera. There's so much potential in this domain. I feel like we could have a lot of fun of it. Maybe we could do it in the form of a rap song or country music. There's so much potential for new, exciting ways of delivering legal opinions, and I'm definitely here for it, man. It's going to be a lot of fun. Just a reminder, of course, the best way to get in touch with me is via my Discord. Tony just gave you the link, so please do that. That's the best place to bring cases to my attention. So if there's something that's happening in the news, something you want a response to, something you think looks legally interesting, the best place to do it is on my Discord. And if it looks interesting, I might just make a video about it. And I love you all. Until next time, I've been Uncivil Law. Till later, my friends, I hope all's well. Cheers for now, my friends, and goodbye.